Good morning. You may sit down. Registrar.
Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Guyana. Hearing of CCJ Appeal GYCV number 12 of 2019 between Shir, Affron and Nabi, Rafael Nabi, the estate of Shir, Aimeen Nabi, and Ashmidphiraque Sheermohamed, S.A. Nabi and Sons Limited, and Maurice Solomon. Hearing this appeal are their honors, Mr. Justice Witt, Mr. Justice Anderson, Madam Justice Rajnath Lee, Mr. Justice Barrow, and Mr. Justice Burgess. Please state your appearances for the court.
May it please, Your Honours, Devendra Kissoon for the appellant.
Christopher Parker for the respondents, appearing with William Hare and Miguel Vasquez.
Thank you. Mr. Kissoon, you can start. I think we decided you both had 1 hour, 60 minutes.
Well,
That's correct?
yes, Your Honour.
I'm used to stick to those timelines as far as I can. I don't think you have to explain too much about the principles that have to be applied in this case. I think we know those principles. Some of them know so much about it that they can even write a book about it, and one of us even wrote a book about it. So I don't think we have to go too deep in that. But anyway, you can use your 60 minutes in a useful way.
Very well, Justice Witt. So we're simply asserting that the trial court and the Court of Appeal after it failed to apprehend that Section 357 of the Companies Act required the court under absolutely every circumstance to first determine if there was any other remedy that was available to the court before employing the drastic remedy of winding up. And those remedies are to be found in Section 2245 of our Companies Act. And in particular, we contend that what ought to have been done is either a shareholders meeting be called or the court supervise a process whereby the appellants or the respondents engage in a process to buy out each other's shares. And that should have been incredibly apparent to the court during the trial itself, where the petitioner's main witness testified at page 1535 of the record. The petitioner was willing to purchase the opposer's shares. That's at question 4. And the opposers themselves also testified that they were very much willing to settle the matter. This is during the trial at page 1613, question 9 of the record.
Yeah, the opposers were willing to settle the matter.
Yes. So both parties.
About the other side, it takes 2 to tango.
Well, the petitioner testified at the trial that the petitioner was willing to buy the opposer's shares. Mm-hmm. So certainly there was enough there to inspire the trial court to take a closer look at what remedies would have been available to the parties in order to end this dispute. And we think that the trial judge was plainly wrong by failing to even consider any alternative remedies whatsoever.
But of course that should have been considered 10 years ago. When
Well,
it started.
The issue of time is a sore point for us. Certainly, if we had a controlled process whereby these matters could have been speedily resolved in the proper setting, that time would not have been expended.
Yeah.
These matters largely originated around 2005, and this matter originated in 2009. But for the court process to take this long to determine relatively simple issues, for us, we believe, has created a false sense of hopelessness. Certainly, when this court heard the matter in 2011, that 2006 matter, then in 2006, perhaps the trial court at that stage should have taken a closer look at the available avenues under 2245 of the Companies Act. I believe it's rather unfortunate that we're here because for our position is We want the matter settled. The principles have since passed. I represent the sons of Aimeen. The petitioner in the matter is also a son of one of the primary litigants. And our clients reside in Guyana. They are very interested in keeping the company alive, especially since Guyana is now an oil and gas frontier. The company has exceptional goodwill. There's sentimental value attached to it in addition to the assets. So we believe that this is something that's quite easily resolved. In that vein as well, the evidence in the record is clear that the petitioner is only a 2% shareholder.
But in all those 10 years, has there never been an attempt at least to mediate, to get to some form of conclusion, some form of solution?
As Your Honor will be well aware, sometimes just to spark a conversation, it's necessary for someone to bring two parties together. And sadly, we believe the court should have perhaps embarked on that very approach, just to try to put the parties in the same room in a non-adversarial setting. To date, that has not been done. And again, this is why we believe Section 357 of the Companies Act was written in the manner that it was written. This is all that had to have been done and explored. It would have been very different if we had come before the court having the benefit of that process and then said, look, it failed, we want to buy, we can't agree to the price, we can't find a proper valuator, or something of that nature. But we're not there yet. And if the court looks at the remedies we're seeking, in this particular case, we're asking this court to take control of the process by directing the lower courts to have the parties engage in some sort of meaningful discussion, to discuss a share buyout, to call a shareholders meeting. Here we have two aggrieved parties who represent a portion of the shareholdings of the company, not the entire shareholdings of the company. So how is it, if we can say that there is a directed deadlock, assuming that were true, don't the shareholders' wishes need to be considered? Ought the court not to have embarked upon that process to simply call a meeting of the shareholders so the shareholders can say, look, this is what we want to do, these are who the directors should be, let's end this. Perhaps that ought to have been considered by the trial judge, and we believe that that's where he fell into error by being plainly wrong.
Now, this is not the only matter between the parties, is it?
No, however...
Do you think that in such a meeting, if it would come to that, you could solve all these problems?
Well, all of the problems are related. All of the litigations, the hundreds of litigations, all touch and concern the same subject matter. Again, a strong court could have easily consolidated these matters. We were new in these proceedings, brought into it in 2015, and we found that there was a general lack of direction by all sides. It's our belief, analyzing the case. We could be mistaken. We're not experts in the field. But just looking at, there's one matter that we highlighted to the court, Matter 791 of 2005, where a lawyer for the appellants here attempted to file a proceeding to have the court call a shareholders meeting, as well as to determine various other matters concerning the operations of the company. That matter today, 14 years later, has not been heard. And again, if the court ought to have recognized, the parties in this adversarial setting ought to have recognized that, look, these matters need to be resolved together. And sadly, that wasn't done, and we're here now. Again, to resolve this matter today doesn't take much.
Counsel, you are making reference to a shareholders meeting. Who are the shareholders?
Well,
is it a widely spread shareholdership, or is it who are the shareholders?
Well, the shareholders are divided. The company has 499 shares. We contend that the shareholdings are owned 191 shares by the appellants, 191 shares by the opposers, and the rest by other family members.
So it's a closed company?
It is a closed company, yes. We also contend that the appellants in this matter control more than 50% of the shareholding, but as the court would have read in the paper...
Is it near danger of majority oppression in that situation?
There could be, but that hasn't yet manifested on the record. There's nothing on the record that suggests that any party is taking advantage of the company for their personal benefit or to damage the interests of the other shareholder.
You said on the record, but in earlier litigation, wasn't this precisely the problem? The fight between the shareholders as to whether there was a directors meeting properly called and so on? Wasn't this part of the history of the conflict between the shareholders?
Yes, the conflict among the shareholders was which family should have control of the company for the purposes of conducting family business. However, at the time that the petition was heard, which is, and the law is relatively clear that the court has to take cognizance of the circumstances that existed at the time of hearing of the petition, the bickering parties, one of them had passed, and certainly another had passed during the pendency of proceedings.
Of course, leaving a son.
Sons on both sides.
Yes, who were also bickering.
Well, they have never had an opportunity to explore the availability of alternative remedies. Assuming the court is right to say that, look, this is going to be an endless battle, there's no point, first, it's our respectful submission, the court should have first explored the issue of a share buyout. Fine. One party has...
you said a share buyout, but isn't it more than that? I mean, isn't this if you look at the history, the making of the company, isn't this a company in which three brothers, I think, set up a company? And isn't the petitioner feeling that he is part of the company? A little more than having a financial interest in the company, but having a founding interest in the company? Isn't this what is coming through from the evidence?
A review of the papers doesn't reveal that at all. In our view, a review of the papers reveals that the petitioner absconded from the jurisdiction from 2006.
You said absconded. What does that mean?
Well, has left the jurisdiction.
That's what I thought.
And not to have returned, as many remigrants do, and has not participated in the management and control of the company, has not taken any interest in trying to do so, but to the contrary, has tried his utmost best, based on the evidence in the record, to interfere with any business of the company. So certainly one could look at it through the court's lens, but looking at it through our lens, we haven't seen any effort whatsoever to express an interest as to what ought to happen with the company. On the other hand, the appellants in this matter are very...
Have annual general meetings been called and properly called as pursuant to the Act?
Reading, whether or not they were procedurally properly called, I don't have instructions for that, but I can tell you the record revealed that the appellants in this matter testified that they attempted to call an AGM twice, and there were some sorts of proceedings to injunct that from happening. And again, we believe that the court ought to have stepped in at that point and called a meeting of the shareholders. The fact that the company was controlled by three brothers is significant because this is a fight between two. If the court were to take the view of looking at it from the perspective of a close corporation, at this point, no one has considered the interests of the other shareholders. So if we have 1/3 disgruntled family section that says, look, this company is not being run in the manner that I would like it to be run, what happens to the interests of everyone else? Certainly, the court ought to have considered that, ought to have considered the interests of the third brother and his children, and call this shareholders meeting.
Have there been directors' meetings?
I've seen many resolutions on the record.
Yeah, resolutions, but
Yes.
have there been directors' meetings?
I have no instructions as to whether or not the directors have actually met.
Isn't this significant?
It is significant. It's significant from the perspective of there's a general lack of consensus as to what should happen next, and this is why. When this court ruled that in 2006 there were two directors that were validly appointed, one of the directors since passed, and there would have been meetings that would have been held or activities, directors' resolutions that would have been passed, either appointing, by both sides, either appointing directors or trying to manage the affairs of the company. Again, at that stage, the court ought to have recognized that, look, we need to call a shareholders meeting to ensure that the proper parties are...
But isn't it up to the board of directors, such as there is a board of directors, to call the meeting?
Yes, it is, but the passing of the persons that happened during the pendency of these litigations simply added more complications to the matter.
What is the nature of the complication?
Well, if it is in 2011, this court decided that there was a properly appointed director who had already passed in 2006, we would then have to unravel what would have happened from 2006 to present. It was just a matter of practicality. So, yes, there are resolutions in the record where directors' meetings, where resolutions were passed. I don't know if directors met or not. But what is then the legitimacy of those resolutions? So one of the matters in contention, for example, and this is a very, very important for the court to take a look at, because it's going to come up now, the issue of forfeiture. If the court could be so kind in dealing with the aspect of a director's meeting to look at page 997 of the record. At page 997 of a record, there's a resolution dated September 18th, 2004, which speaks to the issue of forfeiture of shares. But if the court were to take a close look at that resolution, in paragraph B of that resolution, it refers to an event in the future, though the...
Mr. Kisuni can't put it up.
I could.
Yes, thank you. Can you zoom it a little so we can see it?
So this is a resolution that's passed, purportedly passed by two directors in September 18, 2004, speaking to forfeiture. The court can see that that resolution is dated September 18, 2004, but it speaks in paragraph B to the enforcement of a lien dated September 23, 2004. So certainly there's something amiss with this resolution. This resolution is signed by the petitioner as well as his father, appears to be Ashmidphiraque Sheermohamed, Sheermohamed. And I think at this point, there are multiple examples of documents that contain errors as to, well, did the directors meet? Did the directors pass valid decisions? What happened in the interim? And I think at this point, the court needs to step in to deal with matters concerning what is it that the shareholders want to do with the company, one, and two, resulting from this, who are the shareholders of the company? They were, at that point, let's assume the court embarks on the course to say, look, let's take the path of least resistance and wind this company up. There still has to be a determination as to who the shareholders are. Where will the proceeds be distributed? Once the shareholders are determined...
Wouldn't that be the business of the liquidator?
Well...
Isn't that, by definition, part of his job?
Well, Your Honor, here, it's integral to then ascertain what the wishes of the shareholders would be to explore the remedy available under Section 357. So all we're suggesting is the court ought to have first explored what were the available alternatives. It hasn't done so, despite the willingness of both sides on the record to meet or to settle. In so doing, before the court could do so, the court ought to have determined the shareholders. If the liquidator could do so, sadly it would be after the fact of winding up. And then only at that juncture, once the options have been explored as to whether or not the shares ought to have been redistributed in a manner that was fair to both parties as well as to the other shareholders, then the court could have then embarked on conversations concerning liquidators and winding up.
But counsel, is there any evidence of shareholders meeting within the last 10 years? Is there any evidence of board of directors meeting within the last 10 years?
I am aware that resolutions have been passed.
Resolutions are not necessarily reflective of a meeting.
No, certainly, Your Honor. I can't tell the court with any confidence that there has been a meeting or not. Certainly, that was not.
But if there have not been, isn't the company moribund? I mean, isn't it a company name? I mean, because by statute, annual meetings are supposed to be shareholders meeting general meetings, are supposed to be held.
The court ought to take cognizance of the fact that these litigations have ensued for the period of time the court wants to know whether or not there have been meetings. And I don't think it is unreasonable to assume that one of the reasons that nothing really has happened with these companies is pending the outcome of these litigations that are taking forever to be resolved. Certainly, if the matters in controversy had been resolved sooner, the business of the company could have resumed. We are terribly afraid that the court would look at this passage of time and say, look, nothing has happened. Obviously, the company is only a company in name. Therefore, the substratum is lost. There's no point. But that's in the context of something. And that's in the context of the parties trying to resolve the matters so the company could continue. Again, coming back to this 2005 action that was filed by the appellants here to try to resolve the issue. What happens in the interim? I am aware that there are many injunctions that were granted by the courts in one way or another, stopping meetings from happening, stopping AGMs from happening. They're not part of the record, though the appellants have referred to it. And all that had to have happened was to first determine, look, can we resolve these matters by a share buyout? Again, the court is only looking at these two brothers. There are three. And it's only looking at these two shareholders. The petitioner in the underlying proceeding doesn't control 50% of the company. So why would it be unreasonable for a court to explore whether or not the appellants here and the other parties could simply buy the petitioner's shares? The petitioner has expressed this willingness. So,
To buy your shares, not to sell his.
well, we haven't crossed that hurdle yet. On the record, there's evidence of that. But again, the court never explored it. That was a cursory comment during evidence. The court ought to have seized control of the process and explore these avenues.
And now you're before this court, so what do you want this court to do?
Well, there are two things we want
Want us
separate.
to explore this possibility?
Well, separate. Absolutely, we would like the winding up order.
How would you imagine that?
Well, the first would have to be a resolution, a final resolution, as to who the shareholders of the company are.
Which is not in this.
Which is not in this, but there was evidence before the court below concerning, there was an allegation in the petition of forfeiture shares. There was some evidence taken concerning whether or not the shares were forfeited or not. On the issue of forfeiture, for example, one of the things that the court would have to consider was that the shares were transferred and recorded in the registry, transferred from one of the deceased's to his sons prior to any resolution that could have been passed concerning forfeiture. This is a matter of fact that must be determined.
Now, before we get into all the detail, what is you want this court to do?
So,
Wait till, say, well, we adjourn the case till we have a solution on the shares?
yeah,
Or just tell us what, in concrete terms, you would want this court to do?
the remedy is written clearly in our notice of appeal. It's quite simply as follows. We would like the court to direct that there be a finding of fact as to who the shareholders of the company are, and thereafter direct that the court explore the avenue of a share buyout and any other available remedy under Section 2245 of the Companies Act.
And who has to find those facts?
The High Court would have to find those facts. It would have to be remitted to the High Court for a finding of...
That is that case that is now resumed after 14 years?
Well, that's one avenue. This also could have been found in this very case. Had the trial judge grasped and grappled these issues that were before it, I'm certain that these matters would have been resolved already. We would have been here with resolutions of some sort of these matters in controversy before the court.
As I understand it, that trial judge has been elevated to the Court of Appeal, so he would not do that.
A trial judge could. The matter,
Trial judge.
yes, a trial judge. And I'm not
Are
speaking.
you suggesting that there be new evidence? What are you suggesting? Because you said that there was no, that trial judge did not grapple with the issues. Are you saying that there is sufficient evidence, there was sufficient evidence before him?
The matter would have to be tried from afresh. So meaning that they would have to be, the focus of this matter would have to be the issue of forfeiture. Who are the shareholders of the company, adducing evidence concerning what would have transpired, and then a finding be made, and after that finding is made, the court considers what avenues it has available pursuant to 2245.
It's not going to happen that this matter will come back long after I have left here?
It could. It certainly could. But again, just because of the multiplicity of litigations, which weren't aided by the old rules that we had in Guyana, through no fault of the court, but we had a very different system until recently. The court itself would have taken cognizance that matters have come from Guyana very quickly to be heard at the appellate level. But why must the appellants here suffer through no fault of their own? What the court is suggesting is perhaps the process is so burdensome, let's take the path of least resistance. And had these arguments been made back in 2005 or 2006 before a court or a case that eventually came to this court today, the matter would have been finally resolved. It just wasn't. And I can't impart sufficiently to the bench that, look, it's not just these two parties that are aggrieved. The evidence in the record suggests that none of the other shareholders want the company to be wound up. Evidence was taken on that issue. None of the other shareholders have even been invited to comment as to what ought to happen. And it's even under the realm of possibility that the shares of the petitioner could be absorbed by the company. And again, we can't lose focus that this is a 2% shareholder. We're not certain as to any other item, but the litigation is encompassed here to deal with all possible dissenting shares. Our party would like to buy the shares. It should be valued. If the petitioner wants nothing to do with the company, there's evidence in the record of a letter that was written to the opposing counsel that, look, we want to buy the shares and end this matter. The company has value to us. We live in Guyana. The company has tremendous goodwill, a legacy of contracts being awarded to it. Why would the court not at least explore that in the context of a closed company? That could not be so unreasonable. It's our respectful suggestion to resolve the matter, quite simply. The petitioner has shown no interest. He isn't there. He hasn't participated in management. He hasn't attempted to do so. Instead, he simply attempted to stymie, at that time, the company's business. If the petitioner also wants to buy the appellant shares, that's something the court can consider and make an order of direction one way or another. It's not a difficult solution to what appears to be a very complicated problem, which really isn't.
Would your clients consider selling the shares?
Yes, there have been conversations internally about that. We would like the matter to be resolved one way or another. The last thing the parties want is for the company to be sold at distressed prices especially at this delicate time in Guyana, where anything can happen over the next few months economically. Why ought the shareholders suffer with the value of their shares if we were to get to that? Would it be possible for it to go to the highest bidder internally? I mean, there are many solutions that the court could find.
Have you ever thought about mediation?
I do know, speaking here from the podium, that the parties did interact in a limited way at some point over the last 2 years, trying to explore settlement. I am aware of this based on my instructions. There have been telephone conversations. However, without the oversight of parties that are trained in this field, I'm afraid it's going to be very difficult to perpetuate those conversations given the distance and the lack of persons to bring the parties together to have those conversations exhausted. The parties are of the same age group. I don't get the impression that there's so much hatred that the matter couldn't get resolved, but the court ought to have explored that.
Counsel, you seem to suggest that the other shareholders, apart from the petitioner, own in excess of 90% of the shares in the company. Am I right to believe that?
No, Your Honor.
You don't.
They own 81 shares of the 499.
No, I'm talking about the other shareholders, the shareholders other than the petitioner.
No, so the other shareholders cumulatively own 81 shares of the 499.
I see.
They're listed in the annual returns on the record, but the shareholdings are 191 to one side, 191 to the other side, and the balance split among
Other shareholders, so which comes to 81%?
No, 81 shares. 81 shares.
In terms of percentage?
It's a maybe 10 or 15%.
No,
But I can give the court the exact numbers.
You said that the petitioner owns a mere 2%
Yes,
of the shares in the company.
correct.
So where is the other 98%?
The petitioners,
The other shares are owned by the father of the
father's
petitioner, the
estate. Yes, father's estate owns, guessing approximately 40% of the company. The appellants own approximately 45% of the company, and the remainder is owned 10% by other family members, which are from the third brother.
So the shareholders don't own, there's no group which owns 90%?
No, there's no group which owns 90%, and, but certainly there is a majority group, considering our 40-odd% and the other available 15%. We are aligned with the remaining shareholders, and cumulatively, our shareholdings make up 54.5% of the company.
Okay.
So there is sufficient here for a majority control and a majority buyout.
And
the
that
companies,
is with, the appellants and these others that you speak of.
Yes, yes, Your Honor. And certainly the company itself is liquid enough. Company has no debt. As of 2014, it is worth approximately $1.5 million based on the financials and the audited returns. The company itself could also absorb the petitioner's shares should the shareholders make that decision. In other words, there are available avenues to preserve. S.A. Nabi Sons is a legendary company in Guyana. It built the coffee statue, the Tacuba Lodge, the National Cultural Center. And the appellants here are in Guyana. They have continued the family tradition of construction. And they do have an interest in the company. The company, it could easily be revived, especially in the day and age of tenders and what's going to happen in Guyana. There is value to it. Ought that simply be discarded? That value is far more significant than the asset. Sorry?
You say it could easily be revived.
Yes.
So is it dead?
No, revived in the perspective of doing certain aspects of construction business.
You don't do construction.
Doesn't do construction. It's dead where construction is concerned.
So what do you do?
Manage real estate holdings. That's the only current business of the company. It has various real estate holdings for which it owns and collects rent.
I understand from what I've read that there is another company that is doing all that construction. Is that right?
There are, at the time of the acrimony that occurred in 2006, both brothers attempted to explore avenues. The petitioner's father opened two companies, Arc Construction and Nabi International. When my clients returned to Guyana, as two boys, they returned to Guyana around 26, they're around my age, early 40s now, having attempted to work with S.A. Nabi Sons, but failed because of the acts of the petitioner as documented on the record, they then started their own company and started to do whatever it is that they do. S.A. Nabi Sons sadly was then caught up with these series of litigations. But yes, the petitioner's father did start two companies, and eventually the appellants here started their own with respect to that. So looking at what's just and equitable here, we don't believe that the avenues were explored at all. It would be remiss of the court to simply decide that, look, there's not enough here. At least the exercise must proceed. There has been no consideration, none on the record, as to whether or not there's an alternative remedy. So it's quite easy to come to the conclusion that, look, this is without any resolution, but there must be a process to that. You can't just, it's our respectful opinion that one can't just come to that.
Sorry, you're basing your argument, as I understand it then, mainly on 357, 2?
Yes, 357.2b.
2B, exactly. Which basically requires the court to be of the opinion that some other remedy is not available to the petitioners.
Yes, and coming to that opinion, a process we would respectfully suggest must be followed.
Yes.
They must explore it.
So I wanted to ask you, given the facts that you have outlined, can you point us to any authorities that might guide us in terms of deciding whether the court exercised this opinion properly? Is there anything that is in the case law that is fairly similar? Or
Well, we have pointed the court to what ought to be the proper analysis that ought to have been undertaken. So first, dealing with the issue of just and equitable, this is to be found at page 2254 of our record of authorities, and relying on the text McGuinness Business Corporations Law, the author there stated as follows, referring to the case of Ree Rogers and Agicourt Holdings Limited, the court cautioned against an overly technical interpretation on case law on the question of whether it is just and equitable to order a winding up. Each case depends to a large extent on its own facts. The power to order a winding up of a corporation on just and equitable criteria is discretionary, and one that should not be exercised where it is contrary to that of the interests of the shareholders, nor should it be in so doing, the court ought to take into account the relative contribution made to the corporation by the applicant and to those that oppose the petition for winding up. And that's significant, simply demonstrated. Here we have a petitioner that has a 2% shareholding in the company that wishes the company to be wound up, and we believe that that in itself ought to be sufficient for the court to say, hey, you know, we can't outweigh your interest to that of the other shareholders of the company that make up the majority. We need to consider what it is that they want. And
Mr. Kisun, what has been engaging me is that you seem to be taking us through a process of reviewing the discretion exercised by the court and inviting us to come to a different exercise of discretion. But the question is, how do you get us to the point of saying that what the court did was a wrong exercise of discretion based upon the authorities and principles that you have obviously stated?
well, it's our respectful submission that it's clear that the trial judge was plainly wrong in exercising his discretion because he did not consider the available alternatives under Section 3572 of the Companies Act. In other words, he exercised his discretion without first meeting the necessary threshold to do so. It was completely ignored. There was nothing on the record that showed that the court even considered, for example, the desire of the petitioner to buy the respondent shares or the offer.
The absence of any reasons is, of course, operative in your favor in this regard?
It may be, but beyond that, it's obvious in looking at the record of proceedings that there was no thought given to this. The evidence was simply taken. There was nothing done by the court to explore any of the avenues that were contained in the record.
But sorry. The evidence was given as to the offer to buy.
So there are two aspects to this.
No, hold on. Is that the fact? Evidence was given, the judge heard people say that this one offered to buy and this one offered to buy or was prepared to buy.
The judge heard during the trial that the petitioner was interested in buying the respondent shares.
Okay.
There was one sentence on the record concerning that.
Right.
And the judge also heard during the trial that the appellants were interested in settling the matter.
Okay.
After the trial, certain affidavits were submitted to the court which affirmatively stated that the petitioner was interested, the appellants were interested in buying the petitioner's shares.
So the notion that there was not any advertence on the part of the judge to a buyout, you assert that? That there was not any advertence on the part of the judge?
Yes, the court never considered what was before it. There's nothing that shows that the court paid any heed to what the other alternatives were. In coming to his decision or the exercise of discretion, there is a note that he wrote that simply says the substratum of the company has failed, among other things, and accordingly, it's just and equitable to wind up.
Where is that note? I think I've seen it, but
The note is to be found at page 1283 of the record.
okay, thank you.
1283?
Yes, Your Honors.
And how does Mr. Kissoon, how does the Court of Appeal deal with that aspect?
The Court of Appeal also formed the conclusion that, well, first of all, the Court of Appeal came to the conclusion that there were no reasons given by the trial judge for his decision.
That is undisputed, isn't it?
Yes, it is largely undisputed.
He's not given a written decision or reasons of any kind.
Except for this one note.
One note, yes.
That may not be sufficient to glean what his reasons were for getting to where he has to go. But in addition, the Court of Appeal came to the conclusion that there was a deadlock, and accordingly, given the acrimonious relationship among the parties, it was just and equitable to wind the company up. Again, failing to consider that there were things that were present in the record that it ought to have looked at, in particular, the share buyout. Had the Court of Appeal come to that conclusion after exploring or having decided that the trial judge ought to have explored it, the trial judge did explore it, and it couldn't work because the parties couldn't agree who would buy who out or at what price, and therefore it was unresolvable, we wouldn't have been here today, perhaps on these grounds.
But how did the Court of Appeal look at that issue of alternative remedy?
The Court of Appeal didn't explore the availability of alternative remedies. It rather jumped to the conclusion that, again, because of the facts and circumstances, there is a deadlock, clearly the substratum has failed, it's the end of it.
So, because from 104 of their judgment, they appear to be looking at that issue. So I'm not sure what you're saying with respect to what the Court of Appeal has said here, and why you submit to us that the Court of Appeal was obviously wrong. Yes, if you could just read 104 so that since yes, since you don't have a junior to put the information to so that we can.
Is it
see
104 of the record or paragraph 104 of the decision?
104 of the decision.
Page 40 of the record.
Yes. 40 or 44.
You could also usefully read at this point paragraphs 96 and 97.
Yes, so paragraph 104, we are not unaware of the provisions. Is that a paragraph to which Her Honour?
Yes.
So again, the Court of Appeal gave no justification as to why it would have glossed over the availability of, failing to explore the availability of those alternatives. Rather, it refers to the jurisdiction of the court to simply wind up the company without exploring those remedies.
97, paragraph 97, that is. Well, it's preceded by 96, but in 97, we say it has been suggested that the solution to the problem is the buying out of one side by the other. This seems to be a sensible approach. These parties do not even speak to each other. If any suggestion of settlement is made by one party to the other, it is immediately viewed with great suspicion by the other and dismissed as such. There has even been a suggestion apparent from the record that one side played a role in the death of one of the earlier protagonists and caused his relatives to flee Guyana. We cannot avoid these realities. Any amicable resolution of this matter requires sober and rational thought. From what we have seen on the record, the level of acrimony and hostility which exists among the parties makes this impossible. Indeed, there are still matters among the parties which are pending in the High Court. So I think they, whether you agree with them or not, but they certainly considered, it seems, the Court of Appeals seemed to have considered these alternative methods and have said, well, given the situation, we don't see anything coming out of that.
Well, there are two responses to that. First of all, it was for the trial court to embark upon the exercise. So whilst the Court of Appeal may have peripherally recognized and dismissed the possibility of a share buyout, the trial judge did nothing to embark upon that exercise. Assuming that this was sufficient for them to have considered it, we simply say that this is an improvident exercise of what the remedy ought to have been. The fact that the parties don't speak...
Sorry, it was an improvident exercise?
From the perspective of, even if it is so that the parties do not communicate and only do so in an adversarial setting,
Right.
they're under a court-controlled process where the parties need not communicate face-to-face. But for example, there's a court-appointed valuator and a mediator or someone else that is appointed for the purpose of exchanging messages between the parties. This happens all the time in acrimonious settings, in matrimonial cases and other serious litigious matters. The entire point of this 3.3572, in our respectful view, is for the court to embark upon an exercise, not to simply look at the parties and say, obviously they've been in court, they're in court now for 15 years because the court process is slow.
Counsel, I think in discussing that, you should remember the question which my brother Anderson raised with you. Whether in looking at 357 and looking at the court's forming of the opinion, what do the authorities say the court must do in forming this opinion? That's the question which he raised with you some time ago, and which I don't think that you, I don't understand that you've given an answer to it.
So the answer would be quite simply to the trial judge himself. There's nothing on the record that suggests.
But then, if the trial judge doesn't do it, the matter goes to the Court of Appeal. The Court of Appeal puts itself in place of the trial judge, and it makes that determination because it has. If it finds that the exercise of the discretion by the High Court was improvident or was not proper, it then, by statute, has to put itself in place of the High Court and make the determination itself. And I think that the Honorable President pointed you to where the Court of Appeal actually went through that exercise.
We are of the respectful view that even though the trial judge, the Court of Appeal has expressed this view, by looking at the evidence on the record, it wasn't a fair conclusion to reach that was from the available facts before it.
But a fair conclusion is not the test.
Certainly, Your Honor, but again, without embarking upon the process to see whether or not the conclusion was fair, they would have come to the conclusion without something more. And we are saying that Section 357 requires that something more to come to the conclusion. We don't believe that the court could have just looked at the papers before it without actively engaging the parties to determine if there was a way forward. What the court has done is come to a conclusion on paper evidence only. What ought to have happened was that the parties ought to have been encouraged to exercise what they desired that they wanted to exercise. That is, exercise of a share buyout, an offer to sell and the offer to purchase. The parties said so on the record. So coming to the conclusion that there's so much acrimony that they don't even speak wasn't sufficient to satisfy the requirements of Section 357. During our reply, we will attempt to point the court to the authorities that we cited that perhaps may add further clarity to the question posed. So there were just two other things, really housekeeping matters. We would ask the court that, given the jurisprudential value of this case, perhaps to consider whether or not Canadian authorities are persuasive in Guyana. And secondly, looking at the winding up rules, we believe that the affidavit evidence and the expansion of that and examination of chief ought not to have happened, drawing a parallel from our prescriptive title rules, that rather winding up proceedings should be conducted on affidavit evidence only, and those affidavits cross-examined. And if the court is minded to agree with that, it may be something that can help the development of this area in Guyana. Unless there's anything else, I respectfully conclude.
Thank you.
Thank you very much. You stayed within the allotted time.
Very well, Your Honor. Thank you.
May I now invite Parker QC.
Your Honours, perhaps we could begin by just bringing some clarity to the shareholding position. And I think for that purpose, if we could turn up the appellant submissions, page 1788. On page, sorry. On page 1788, the third paragraph, we see the opposers' statement of the shareholding position. They say 499 outstanding shares, that's agreed. The opposers, they say, hold 191. The petitioner holds 9 shares. The estate of Aslim, which is allied with the petitioner, 191 shares. And the estate of Aziz, 81 shares, with a remaining 27 divided equally among 3 other siblings. Now, the critical point is that as a result of the forfeiture resolutions back in September 2004, the opposers' shares have been forfeited, and the 81 shares of the estate of Aziz have been forfeited. That forfeiture is what we are referring to when we talk about the dispute over the share ownership. So, pursuant to the forfeiture resolutions, the opposers don't actually hold any shares. And as I'll elaborate in due course, the position on the forfeiture resolutions is that they were challenged before all the way to this court on the basis that they were passed by an improperly constituted board of directors. And in May 2011, this court gave a judgment holding that the board was properly constituted, and therefore the challenge to the forfeiture resolutions that was being made in the notice of motion before the court failed. It is also the case that proceedings had been commenced in 2005 by the opposers, challenging the forfeiture resolutions on other grounds that they referred to as being grounds of fraud. And those are the proceedings which have languished for these past 14 years. So obviously we say the position is that we have valid board resolutions forfeiting their shares, and if they want to proceed on the basis that they are still shareholders, then the burden's on them to have those otherwise valid board resolutions set aside. As I reiterate, those are the 2005 proceedings. So that's the share ownership dispute. Now, we invite the court to dismiss the appeal for the reasons we've set out in our written submissions. But obviously, like my learned friend, I will be concentrating on the principal challenge to the judgment of the Court of Appeal, namely that there were alternative remedies that were insufficiently considered by the Court of Appeal. I'm grateful to this Court for taking the time to consider those paragraphs 96, 97 and 104, which is clear the Court of Appeal did consider the alternative remedies. This is not a case whether you say, well, he just completely overlooked it, as my honourable friend was initially seeking to say. And we say, on this point about the alternative remedies, that the appeal must fail because the appellants cannot complain on appeal about the trial judge and the Court of Appeal not doing something that they were never asked to do. Now, the two alternatives, as we all appreciate. First of all, the alternative it is suggested is that the appellants should be allowed to purchase the petitioner's shares, or alternatively, the shares of the petitioner and those of the estate of Aslim. They seem to fluctuate between that. But without more, the problems with that suggestion we have listed in paragraph 35 of our submissions. And just to, if I could remind the Court of those, they're to be found at page 4208. And if the Court would be so kind as to cast their eye down over those myriad problems, the Court will see that amongst that list of problems is the fact that one doesn't even know what shares we're talking about. The parties have got diametrically opposed views as to how many shares the petitioner's side of the dispute own. The petitioner's side say they own 463. There's been no suggestion that the appellants are prepared to proceed with a purchase on the basis that the number of shares held by the petitioner's side is 463. Similarly, with the alternative suggestion of a shareholders' meeting.
Sorry, where do the 463 come from?
The 463, if you, the forfeited shares
Right.
have been acquired
Right.
but on the petitioner's side.
I see.
In the estate of Aslim.
Right.
So the figures I took you to at the beginning,
Yes.
they're the figures being put forward by the appellants.
So 191, etc.
Yes, but we say the 191 and the 8081 have been forfeited and acquired by Aslim.
Clear.
Yes. So that's why the principal reason for saying, apart from all the difficulties about, well, what are the assets, blah, 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 the principal reason is it's a non-starter, the purchase suggestion, because there's a controversy over what the relevant shares are. The second alternative is a shareholders' meeting. And one asks rhetorically, how can one possibly have a shareholders' meeting in circumstances where it is the position of the petitioner's side that the appellants aren't even shareholders? There has been a shareholders' meeting. Page 1744, we can see a meeting of shareholders in 2012, but it was just between the petitioner and his mother as the executrix of the estate of Aslim. So effectively, you've got two camps who are working on different agendas because of this dispute over the shares. Now, we say, therefore, it was obvious that neither of the suggested alternatives are viable whilst there's a dispute about whether the appellants are shareholders and conversely about the extent of the shareholding in the estate of Aslim. Now, that obvious failing with the alternatives has been recognised and accepted by the appellants in their written submissions. And if we could please turn up page 1787, we can see that.
Which one?
87.
I've got it right. We see at the bottom of page 1787, which is in the summary of arguments section of the appellant submissions, that they say, accordingly, for the reasons stated herein, the winding up order should be set aside and the company allowed to freely conduct its affairs in the same manner as before the trial court's orders issued, until there is a determination as to the ownership of the company's shares, and thereafter direct that a shareholders' meeting be called. So they're not saying that as things stand, there are any viable alternatives. They're now accepting that the alternatives are non-starters as things presently stand. And we see that also in their grounds of appeal to this court, which, if one turns to page 11 of the record, in answer to the question, what order are they asking this court to make, we can see that on page 11 at paragraph 3. And for present purposes, the focus is on subparagraph B. Before this court, they ask for an order remitting the matter to the trial court to indicate a finding of fact to determine the true shareholding of the company, and thereafter direct a shareholders' meeting be held with a corresponding order. So, these grounds of appeal and these written submissions accept what is obvious is the court cannot do anything sensible whilst the share ownership dispute is extant. And that is a fundamental point on which the parties are agreed. Now, given that that's what they're asking this court to do, to remit the share ownership dispute to the trial court, one would expect there to be a ground of appeal complaining of a refusal by the Court of Appeal to order that the share ownership dispute be remitted to the trial court. But there is no such ground of appeal because the Court of Appeal were never asked to remit the matter to the trial court. So if we go to submissions 1786, excuse me a moment. If we go to the appellant submissions at 1786, we can see at the bottom of that page that when they come to consider their complaint with the decision of the Court of Appeal, they say, even more egregious, despite the fact that there remains a dispute as to ownership of the company's shares, the court declined to resolve this dispute. And we see that if we go to the grounds of appeal from the trial judge to the Court of Appeal, which we have at pages 154 to 155,
Could you give us those pages again, Mr. Parker?
154 to 155.
Thank you.
So these are the grounds of appeal from the trial judge to the Court of Appeal. And we see that at subparagraph 27 on page 154, there's a complaint about the failure to consider the forfeiture issue, and we see at the end of that, and failing to make a corresponding pronouncement on the same. Now, that's a complaint in this ground of appeal that suggests that they ask the trial judge to decide this issue. I'll park that for the moment. But when one goes to the relief that they're seeking from the Court of Appeal in paragraph 4, subparagraph B, one can see that they were asking the Court of Appeal to decide the share ownership issue. They weren't asking the Court of Appeal to remit it to first instance. They were asking the Court of Appeal to decide the issue. Now, we say, well, once again, it's a recognition in the grounds of appeal that the suggested alternatives aren't viable unless the share ownership dispute is determined. But it's different, obviously, to what they're now saying. So this point about wanting the Court of Appeal to decide it is also to be found in their written submissions before the Court of Appeal. If we look at page 1205, we see again in the written submissions in the middle of the page, they're even more egregious. Despite the fact there remains a dispute as to ownership of the company shares, the court declined to resolve this dispute, again suggesting that at first instance they had asked the trial judge to resolve the dispute. And then if we go to page 1227, in the paragraph above, subparagraph F, central to the matters in controversy between the parties is the issue of forfeiture of our shares. Well, that's a correct statement, we're all agreed on that. If this matter is not finally resolved in the instant proceedings, this case will continue to languish. Now, having looked at the way the appeals have been formulated in respect of this issue, we remind ourselves, not that this court needs reminding, but others do, that this is, of course, an appeal from an appeal. The question for decision by this court is whether the Court of Appeal acted unreasonably in deciding that the trial judge had not acted unreasonably in deciding that there was no viable alternative to a winding up. And as I've said, that issue falls to be determined on the basis of the now accepted common ground that the alternatives were not viable unless there was first a resolution of the share ownership dispute. Now, the Court of Appeal, as we've seen, was being asked to determine the share ownership issue itself, which as an appeal presupposes that the trial judge was asked to determine the dispute, but refused to do so. And we've seen how the grounds of appeal and the written submissions were formulated as if he had been asked to determine the dispute. But of course, in truth, he wasn't asked to determine the dispute at all. You had the forfeiture resolutions which this court had said were valid. So the only remaining challenge was the 2005 challenge based on grounds of fraud. And we have seen that the Court of Appeal was being asked to determine the issues of fraud. But we say that the appeal is misconceived because the trial judge was never asked. And we see the admission of that fact in the written submissions at page of the Appellants at page 1820. And we see at the bottom of page 1820, from the onset, it is important to note that the issue of fraud has not been ventilated in the lower court proceedings. Well, one can look at the transcript and everything to show that that's absolutely right. Before the trial judge hearing this petition, there was no suggestion that he should be determining the allegations of fraud that are being made in the 2005 proceedings for the purpose of challenging the forfeiture resolutions. It simply wasn't open to the appellant, therefore, to seek to appeal the trial judge's decision on the basis that he ought to have decided the share ownership issue. He was never asked to. And therefore, before the Court of Appeal, the appeal on this issue was bound to fail. Because, 3 reasons. The Court of Appeal doesn't conduct trials. It'd have to be a trial of the allegations of fraud. Secondly, it never had the material before it to decide the allegations that were being made in the 2005 proceedings. And thirdly, and most fundamentally of all, the trial judge had never been asked to do so. So the Court of Appeal couldn't be asked to do so. So it cannot sensibly be said that the Court of Appeal acted unreasonably in not deciding the share ownership issue. And therefore the ground of appeal 1 before this court fails. And what we've seen, of course, from the grounds of appeal is the Court of Appeal were not asked, as I've said, to remit the matter of the share ownership dispute to the trial judge. Well, effectively to stay. It's not quite clear what happened to this petition on my learned friend's suggestion that the matter goes to the trial judge. Is the petition remains extant, presumably, pending the determination by the trial judge. So he's asking for a stay. But the Court of Appeal was never asked for a stay. So he can't complain that the Court of Appeal didn't consider the issue of the stay, and indeed, as I pointed out, he doesn't. It's not in a ground of appeal. So he can't now come to this court and say there should be a stay, pending a determination at first instance of the share owner dispute, when that was not a position that was adopted before the Court of Appeal. Now, in terms of the trial judge, what we are told in the appellant's submissions by way of a footnote is that the appellants issued a summons before the trial judge to have the trial judge stay the petition, pending the determination of their 2005 challenge to the forfeiture resolutions. And the trial judge dismissed the summons. But there's no appeal against his dismissal of the summons. And that is why there's no mention of any stay until we get before this court, by which time it's simply too late. So there's been no consideration of the evidence that was considered by the trial judge when he dismissed the summons. Consideration of that evidence may well show that he was perfectly within his rights. Well, it's perfectly sensible to dismiss the summons, but we've no idea because we're not being asked to consider the trial judge's determination of the summons that's seeking a stay. It's just not been appealed. So there's no appeal against the refusal of the stay, and no possibility of their saying that the trial judge should have determined the share ownership because they never asked him to do so. And therefore, when one gets to the Court of Appeal, the appellants are left in the position of asking the Court of Appeal to accept the alternatives of a buyout or a shareholders' meeting as being viable, but without a determination of the shareholder dispute, which they have recognised in their grounds of appeal needs to be determined first. So the the appeal is simply misconceived. It's utterly illogical because the grounds of appeal accept. The alternatives are hopeless unless the share ownership dispute is decided first. That requires either a stay, which is not the subject of the appeal, or a determination by the Court of Appeal, which the Court of Appeal can't do, because, not least because the trial judge wasn't asked to determine the issue as being accepted. Now, we say that, well, as an aside, simply as an aside, because we say, given those submissions, the appeal based on alternatives is clearly hopeless. As an aside, the trial judge was obviously right not to stay the petition pending a determination of the 2005 proceedings. And because all these years later, the 2005 proceedings have not been progressed.
Counsel, just as a matter of conceptual exploration, is there any impact on the making of the winding up order that the shareholding is so much unresolved?
Yes, because the forfeiture was, the question of the forfeiture was before the court.
Right.
In the sense of, it was alluded to. The parties were, the court was conscious of the fact that there were forfeiture resolutions, because that's alluded to in the petitioner's evidence.
Right.
And as you appreciate, the difficulty is we don't have any written judgment to know precisely what the mental processes of the trial judge were.
But should the fact that the shareholding was in dispute have detained the judge in relation to making the winding up order?
Well, we would submit not. We say that both the trial judge and the Court of Appeal proceeded on a basis favourable to the appellants. Neither the trial judge nor the Court of Appeal treated the shares as having been forfeited for the purpose of argument. They entertained the appellants' arguments on the basis that they had locus to make the submissions that they did. And as we've seen, the principal submission based on alternatives. But they didn't need to determine the issue of the share ownership because they were acceding to the petition. Now the petition, if they had dismissed the petition, one anticipates, I'm not sure anticipates the right word, there's a future concept there, one imagines that the petitioner would then have sought to appeal a dismissal of his petition on the basis that the prima facie position, because of the validity of the board resolutions forfeiting the opposer's shares, is the opposers had no locus. I mean, the opposers initially opposed in the name of the company. But of course, that's the very thing which is in dispute in the share ownership dispute. This is a case, I don't know whether you're alive to this fact, and as they assert in their submissions, the opposers have controlled this company since 2007. So despite the success before this court in May 2011 of having the challenge to the validity of the forfeiture resolutions based on our board being an improper board, having that challenge dismissed, the opposers have just ignored it. And Ashmid has had to absent himself from Guyana. There's a reference to it in paragraph 97 of the judgment. His father was murdered. Now, that was originally, the murder of his father, following the falling out, was in the petition and had to be removed as an abuse. But the Court of Appeal recognised that if the opposers are then going to say, oh, but he's absented himself, if they're going to rely on that, then obviously it's open to Ashmid to explain why he's absented himself. So it's a serious situation that we go all the way to the Caribbean Court of Justice for the purposes of having the challenge to the forfeiture resolutions dismissed, but it's simply ignored. So we have forfeiture resolutions which have yet to be set aside on grounds of fraud that are just being ignored. And that's why we say that if you're going to press, as they did in their grounds of appeal, the Court of Appeal, to pronounce on the share ownership, the only thing the Court of Appeal could have done was to proceed on the basis of the forfeiture resolutions, which this court had held to be valid. So the prima facie position, I reiterate, the prima facie position is the opposers don't have any shares. The Court of Appeal sensibly said, well, we, the Court of Appeal, don't need to say that because we are acceding to the petitioner's petition. So, as I say, the Court of Appeal proceeded on a basis favourable to the respondents, but on the basis that the respondents at that time were not putting forward any sensible mechanism to the Court of Appeal as to the resolution of the share ownership dispute, and couldn't because they hadn't at first instance. The Court of Appeal rightly treated the alternatives as simply not viable. And we say that even if all that is disregarded, and even if one can simply say, well, let's look at it now, the simple fact is that, as we say, it would be a travesty of justice for the petition of the petitioner's side to be dismissed at the behest of people who haven't even established that they're shareholders. They say, oh, well, we've got these 2005 proceedings, but the inference is that they prefer to use the existence of the 2005 proceedings as a fig leaf, of an excuse to remain in control of the company despite the May 2011 judgment of this court, rather than actually get those proceedings decided. There's no evidence supporting Malone & Friends' insistence that it's not their fault. There's no evidence of them writing to the court, urging the court to progress their 2005 proceedings. It's simply an empty statement by my friend to try and explain the extraordinary situation that these proceedings have been languishing for 14 years. In contrast to the challenge that was made on the basis of the board allegedly being improperly constituted. That managed to get itself heard and go all the way to this court by 2011. So it was open to them to put forward all their challenges in one proceedings, and it would have been determined by now. So we say, look, there's simply nothing in these alternatives. They went to the trial judge on the basis that they simply wanted the petition dismissed without asking the trial judge to determine the issue and without there being any appeal against his earlier refusal of a stay in the summons. And I think this court will have seen and heard enough to appreciate that the suggestion that there's nothing to support the findings of fact or in the Court of Appeal about the level of acrimony and hostility between the parties is a simple risible suggestion. These parties have been at loggerheads over the share ownership for a long, long time. There are allegations of financial impropriety. The Court of Appeal didn't think it necessary to decide them because the Court of Appeal was proceeding on the basis that there was deadlock in the broadest sense of the term. This is an utterly dysfunctional company that is being run by people who, according to the Caribbean Court of Justice ought not to be running the company because they don't have any shares.
The deadlock is essentially flowing from the shareholding dispute?
In my submission, we can have it both ways.
Okay.
Obviously, if the 2005 challenge wasn't there as an excuse, then it would be absolutely clear that the opposers don't have any shares. It would be absolutely clear that there's no justification whatsoever from them running this company. And in those circumstances, we could have got, one would have thought, some sort of injunctive relief, because we would own 463 of the 499 shares, because we say we do. In contrast, if the 2005 proceedings had been determined or were at some point in their favour, then it's our position that that gave them a maximum of 54% if other people supported their position. But that wouldn't resolve the problems. Because of the level of hostility that the parties have now reached, there couldn't be any sensible consideration by that majority as to the rights of the minority. So we have a situation where, as things stand, it's clearly dysfunctional, but there isn't even a prospect at any point in the future of this company being conducted on a sensible basis, because we've seen no efforts on their part to progress the 2005 proceedings. We're simply left with it being this fig leaf to justify them kicking us out. And on that basis, as I say, even if they determined it, and it got determined in their favour, one couldn't expect to have any access to information, one couldn't expect to be given dividends in the usual way. So in the exercise of the discretion, we would say the court can say, well, it can look at two things. It can look at, well, they're running the company with this claim to have the forfeiture resolution set aside, that they've done nothing to progress. Secondly, that in itself indicates they don't actually think it's a very good claim. And thirdly, even if the claim were to succeed, one couldn't expect them to conduct themselves in an appropriate manner on the basis of this very slim majority that they hold. They would then hold. But all that, we say all that's rather beside the point, because, as I say, none of that was ventilated before the trial judge. It was simply on the basis, look, Judge, dismiss the petition. Trial judge wasn't asked to decide the issue of the shares. Now, in terms of the various disputes, you may have picked up on the references to the various returns. Maybe for your note rather from anything else, but a contrast of pages 4168 and 4180 illustrates the point. You have two annual returns for the same year, 2004. One's filled in on the basis of the shares being forfeited by the duly constituted
Sorry,
board.
4168 and what?
4168, if perhaps we'll look at it, shall
No,
we?
4168 and the second number was what?
Second number is 4180.
Okay.
4168, we see the shares forfeited. We don't see the shares transferred to Aslam's estate, because at that time the full purchase price had not been provided, but we see the shares forfeited. 4180, same year, we see a return signed by Aimeen as a director, setting out the opposers of still having their shares. And we see other examples subsequently. So this is the dysfunctional nature of the court. You just have two camps, one of which is proceeding on the basis of the May 2011 decision of this court, one of which is just ignoring it.
Well, the only solution both suggest is buy the other one out or the other one's out. So that seems to confirm they cannot live with each other.
Yes.
If that is the only solution they see.
Yes, well, there's no suggestion the parties can cooperate. The shareholders' meeting is just a nonsense. Quite who attends this meeting? As I said before, you get two different versions of the meeting. We've had a meeting. They say that's not a shareholders' meeting because we weren't there. We say you weren't there because you're not shareholders. And just be absolutely clear that we put in the 2009 return in evidence, not for the purposes of saying that the contents of the 2009 return that showed them as still being shareholders were accurate, but simply for the purpose of illustrating that despite the decision of this court about the forfeiture resolutions, they're still putting in returns as if they're shareholders. And my final point was really just to say, in the context of clean hands, to refer you to paragraph 31 to 33 of our written submissions, that it is not good law to say the petitioner must have squeaky clean hands. There is a statement in Ibrahimi that if the petitioner is responsible for the breakdown in the relationship between the parties, that in those circumstances it might be appropriate to dismiss the petition. But that's not the situation here. There's no suggestion that the petitioner's responsible for the breakdown in the relationship between the parties. The Court of Appeal proceeds on the basis they're as bad as each other. But the Court of Appeal rightly take the view that simply because it can't be said the petitioner's got clean hands doesn't debar him from asking for relief from the court. And we've cited a couple of authorities to that effect. Unless there's any questions from the bench, I was proposing to conclude there.
Thank you very much.
Thank you for listening.
Mr. Kisoon, short reply.
Your Honour, just dealing with the issue of the remedies requested to the Court of Appeal. We do disagree that the remedies sought here were not requested there. They are contained at page 1173 of the record. And in any event, Section 7.2 of our Court of Appeal Act allows this court to fashion remedies that's necessary to do justice between the parties, whether or not they were asked for. But that's just is as on the side. Section 1173 of our Notice of Appeal to the Court of Appeal specifically asked the court to consider the reliefs that were contained in the summons to the High Court, which included staying the matter to determine the 791 of 2005 case to determine the shareholdings. It was very much a live issue before the Court of Appeal. There's nothing new that's been raised in these proceedings.
So you included that in this notice of appeal
as well,
but you didn't appeal the dismissal of the stay of the application for the stay.
The application, right? The dismissal of the stay. No, there's nothing on the record.
You did not appeal
concerning
that, but you put it in this appeal
and the Court of Appeal.
That's what I mean. Sorry,
yes.
You put it to the Court of Appeal. I understand.
Yes, we took the request to recall the provision order appointing the provisional liquidator. That decision dated February 15th as the final decision of the entire proceedings and appealed directly to the Court of Appeal. The issue of forfeiture has not been determined. As my learned friend has alluded to, there's a peripheral inference that there is a resolution that was upheld that mentioned forfeiture. Forfeiture has not been determined by this court. And even if it is argued that the resolution that was upheld by this court did encompass forfeiture, it encompassed forfeiture only by name. The process of forfeiture has not yet been determined, There are many evidentiary discrepancies concerning whether or not the shares have been forfeited. And just dealing with the fact alone, the petitioner alleges that the shares were forfeited based on a $70,000 US debt to the company. That's the genesis of the dispute. The company is worth $1.5 million, and assuming that the appellants roughly had 50% of the company, the petitioner is attempting to say that, look, because of that $70,000 debt, which is disputed, but that because of that debt, the shares have been forfeited and therefore we own the company. This is a matter that's ripe for determination. The issue of forfeiture also, if you look at the probate papers, which are part of this record, contained in 1735 of the record, the probate papers of the deceased, the father of the petitioner in his probate, the value he attributes to his interest in this company is equivalent to the shares that we believe he owns, 191 shares. So there's a lot of issues there to be determined that have not been finally determined, and we refute that allegation. The issue of...
But sorry, counsel, does that not tend to support Mr. Parker's thesis, which is that if all of these fundamental things cannot be resolved, are not resolved, it is just simply mass confusion and stultification that you're dealing with?
Well, it needs to be resolved because if, for example, we were to uphold the winding up order and liquidate, where do the proceeds go?
Okay.
What happens? It's a matter that needs to be resolved in our respect for submission before anything else can be resolved. Because once the shareholdings are determined, then the remedies ought to be explored and ought to have been explored by the trial judge, and I'm coming there. But what the madness is not solved by the winding up order. Nothing is solved. It only makes it worse. And what's going to happen is that even if the assets are liquidated and they're going to be held in some account, the company losing the value of appreciation of its assets and so on and so forth, until that issue is resolved, this is something that the court, once and for all, ought to direct be resolved, to resolve the matters in controversy. And if it is resolved in the appellant's favor, that they do control 54.5% of the company, the exercise of the available remedies under 2224 become much easier concerning the share buyout.
Well, that means that as Mr. Parker was saying, that the available remedies are not available until the question of the shareholding has been settled.
Yeah, I don't think that's...
You're saying the same thing?
Yes, it's a logical step, and those steps are put in our notice of appeal to this court. The court, when we had applied to the court, in making an application to the court to stop your decision on winding up and determine this issue or stay the winding up proceedings pending the outcome of 79105. We applied to the court for that relief, and the judge refused and instead ordered the company to be wound up. That application is part of the record before the court and something that we found extremely puzzling, because how does that resolve the matters in controversy in any event? And that request for relief was repeated to the Court of Appeal and is now being repeated here. The issue of the shares needs to be resolved. This court can simply say we uphold the winding up order and perhaps leave it to the liquidator. That doesn't do justice to the parties or resolve the matters in controversy in our respectful view. The allegation that the company, there's been a complete looking away from the court's order, this court's order in 2011 isn't an accurate one. The control of the company is pursuant to an order by the trial judge who ordered the state of affairs as it currently is to be so. And I'm just trying to find that order for the court. The control of the company is pursuant to a court order, which is to be found at page 1068 of the court's record. And that's something that has subsisted today. Even the Court of Appeal of Guyana, in considering whether or not control of the company should remain as it was and it has been, considered that it should remain where it was pending the outcome of these proceedings and give certain reporting requirements to the appellants. until such time as the matters were finally resolved. This was something that was considered by the Court of Appeal in these proceedings in February of 2016 as part of our stay application. The issue of the demise of the petitioner's father, this is a very sensitive matter for the parties, something that certainly our clients take great umbrage to certain allegations. There are facts that occurred, but at page 4387 of the record, this matter was decided by the trial judge in these proceedings. The references to what happened were to be struck from the record as being scandalous, and we would just like to point the court to that look, it is struck from the record. It has been, that order hasn't been appealed and continues to today. And then dealing with really the looming issue of the interference with the discretion of the court below. The court has pointed us to what the Court of Appeal expressed as its review of the facts. But what is really under challenge here and was under challenge of the Court of Appeal was the trial judge's exercise of his discretion. And we respectfully submit that the trial judge did not express his discretion in the manner that he should have, because he didn't take into account the principles that are enumerated in section 3572 of the Companies Act. He failed to take into account of the relevant considerations that were before the court and didn't take any account of the evidence that was before him of the share buyout. So had he done so and had he dismissed it and said, look, I have considered this, but despite me considering this,
Mr. Kisun, aren't you left with the fact that the Court of Appeal has dealt with it?
The Court of Appeal has substituted its discretion for the trial judge's discretion. We think that that is also impermissible because we are looking at the trial judge's discretion.
No, with the greatest respect, what you are doing, you can only challenge the decision of the Court of Appeal.
Well, then we would say that the Court of Appeal exercised its discretion improvidently by not considering what were the available avenues under 357 in a manner that was contemplated by the law or that was before that was contained in the evidence before it. That's our position where that's concerned. And the matter
Asked to look at alternatives? Was he asked by the parties to look at those alternatives?
No, there was no specific application on the record by either side to consider what were the available remedies at the time. We do think that the court ought to have considered them as he was required to by statute. He need not to have been asked, but ought to have looked at the evidence before him and exercised what was required of him pursuant to the statute. After the trial, a summons was filed by us to bring to his attention that we were interested in purchasing the petitioner's shares, and at that stage, prior to the issuance of the winding up order, he refused to consider it, giving reasons of fresh evidence and otherwise. But it's for...
When you say prior to the issuance of the winding up order, where do you see, or when do you say the winding up order was made?
We see the winding up order being made in February of 2016,
All right.
but the consideration under appeal remains the same. Wherever he exercised or failed to consider 357, be it in June of 2015 or February of 2016, there was sufficient before him to come to the conclusion that, look, I need to explore...
No. We are talking about the affidavits filed subsequent to to what the other side says was the winding up order.
No. So I'm suggesting that even if one were to disregard those affidavits, the evidence in the record, which I read to the court, demonstrated that I want to buy the shares and the matter can be settled, and that ought to have been...
I was dealing only with the point about looking at the affidavits. That's
So certainly we would argue that affidavits ought to have been looked at because they were properly before the court.
Okay.
But regardless of which way you go, the outcome, it's our respectful view, is the same. And we would urge the court, if you leave the parties hanging by upholding the winding up order, there is no resolution to this. All that has to be done is a finding of fact made as to who the shareholders are, and then the parties can explore a buyout. And if not, the winding up order will then take effect. But that ought to be the exercise of justice in this matter. Unless there's anything else, Your Honors, those are respectful submissions.
Okay, thank you very much.
Thank you very much.
Well, we will consider everything that has been said from both sides, and we will deliver a judgment, as I used to say, within a reasonable time.
Yeah, have a safe trip back, yeah.